Good day, everyone. Welcome to the webinar, Impact of COVID-19 on Behavioral Health Industry, News and Views You Can Use. As I'm sure you know, online access is being used more than ever during this time, and so the quality of the presentation may be strained at times. If you're experiencing sound or technical issues, please comment in the chat room and I will address it as soon as I can. My name is Angie Fiedler-Sutton, and I'm with the Behavioral Health Association Providers. The Behavioral Health Association Providers, otherwise known as BHAP, is a national trade membership association that provides education and advocacy for behavioral health care providers and related entities. Formerly known as the American Addiction Treatment Association, BHAP is the leading and unifying voice of addiction-focused treatment programs. We provide membership opportunities such as networking opportunities and various benefits, educational opportunities such as this webinar and our Certificate in Addiction Treatment Marketing, CATM, and advocacy efforts to keep those in the industry aware of new laws and regulations that may be coming that will affect them. But a membership in BHAP gives you something everyone finds valuable: time. Working in the behavioral health industry or managing an organization in the industry can be incredibly complex and filled with ever-changing information for compliance. BHAP gives you resources to stay on top of the rules and regulations for your organization to stay compliant. For more information about BHAP, you can visit our website at www.bhap.us. Before we begin the webinar, a few housekeeping details for those of you joining us for the first time. You will be able to hear us, but we won't be able to hear you. That's because we record these webinars so you have access to them later if you need them. However, if you have questions or concerns, you can use the chat room on the lower left. You don't need to wait until the end for questions. We will be sending a link to the webinar and a PDF of the slides via email after the event. Make sure to keep an eye out for it. It will be coming from bhap.us email address. Thanks to our co-sponsor, Southwest Associates. They provide intervention, compliance monitoring, and sober companion services nationally. More information about them can be found at www.southwestassociates.net. And now, it's my pleasure to introduce our presenters today. Balch & Bingham is a full-service law firm recognized for its exceptional understanding of regulated industries, including the behavioral health industry, and its deep experience serving them across a full range of practice areas. Balch & Bingham has formed an interdisciplinary practice team focused on anticipating and meeting the broad range of needs in the behavioral health industry. Thank you for taking the time today. With that, I will hand the webinar over to Walter Boone.
Good afternoon. My name is Walter Boone, and I am a partner with the law firm of Balch & Bingham. Welcome today. We apologize for the technical difficulties, as I'm sure all of you have experienced. We are doing a lot more of these by this mechanism, and the sheer mass of people moving online has created these technical difficulties, and for that we apologize. But today we are here to talk about the impact of COVID-19 on the behavioral health industry, and we're going to focus on providing news and views that you can use. Balch & Bingham is a full-service law firm. We have offices across the southeastern United States with a practice nationwide. I want to thank again our sponsors, BHAP, for allowing us to have this platform, and Southworth and Associates for also sponsoring this event. We understand and know that you and all industries in general faced risk from very many different quarters. We pride ourselves on serving our clients and helping you manage those risks. In the behavioral health field in particular, we also understand that there are different needs that you have from a variety of different sectors, from healthcare to government relations, to corporate, to litigation, to labor and employment. You need, and we provide, broad range services from very distinct and different practice areas. We have formed a multidisciplinary task force and team to address the many needs that the behavioral health industry seeks, and I am privileged to lead that team. We know that the COVID-19 in a matter of weeks has changed everything. It is unprecedented in every way. It is global in nature. It is serious in health impact, and its financial consequences have yet to be seen. And we know that the COVID-19 outbreak is affecting you in particular in a variety of different ways. First, as a healthcare provider, You are wondering and worried about how it is that you are going to do what you need to do in this new environment. And particularly as a behavioral health care provider, you are wondering how this is going to impact your particular sector particularly. You also have concerns, and we know those concerns because you are an employer. What are you supposed to do with your employees, and how are you supposed to act in this new world? We know that you need, and it will be impacting you as a business, and last but not least, as a citizen. To meet those variety of needs, we have formed at Balch and Bingham a focus group, which is available to meet the needs of businesses as we work through this unprecedented situation. The website there is a link to our practice group, our focus group webpage, and it is being updated daily, hour by hour, with new information and content regarding information and insights about how to deal with the COVID-19 situation. Our program today will focus on these topics on the screen right now. Each topic will be approximately a 10-minute segment. Hopefully it will have hard-hitting information that you can use. With it, there will also be resources that can lead you to further information. I would advise you to keep a regular or in regular contact with our COVID-19 focus group page, because that's where new information will be presented on a timely basis. A couple of caveats in the not so fine print. The information that we're going to be talking to you today is information and not legal advice. We are not undertaking any attorney-client relationships by this webinar, and we do encourage you to seek counsel if you need counsel. Things are changing rapidly, and we are going to give you the up-to-the-date situation as we appreciate it, but these things, as we all can see and know, are changing hour by hour, day by day. State by state variations may be significant, and you should check with your local and state rules on the particular subjects covered here. Lastly, these issues are complex. Our presentation is designed as a hard-hitting and concise summary, so some of the detail, of course, we cannot present today, but nevertheless, these are our views on these issues, and we are certainly available for further consultation. First of all, let me introduce to you my partner and friend, Pepper Crutcher. Pepper is a member of our Labor and Employment Practice Group and advises and advocates on a wide range of private sector employers on issues facing employers. Most recently, Pepper has been giving day by day, and in many cases hour by hour, updates on how the new legislation and new regulatory regulations relating to that legislation affect employers. Pepper Crutcher, take it away.
Good afternoon. My subject is what has been called in political circles the second stimulus bill, not the one that the Senate passed last night, but the one that passed both houses and was signed by the president last week. It's called formally the Second Coronavirus Preparedness and Response Supplemental Appropriations Act. If you want to go to congress.gov, you can look it up as either H.R. 6201 or Public Law 116-127. And I'm only looking at certain features of that law, that is the employer obligations and opportunities of the law. The first section I'm interested in is the division of the law that changes state unemployment insurance programs. There's a great deal of extra money that will start flowing to state UI programs in May. To get the state's share of the funds, the state must require employers to give unemployment compensation and availability notices at the time of termination. The state must waive work requirements, if any, in current state law. The state must waive the waiting week, currently in state law. And the state must non-charge employers for claims due to workplace illness or quarantine or isolation orders. Now, in our footprint, the state has already done this. The odds are your state authorities have done this where you are. Most of these state authorities have websites you can check and see, but they all want the money and they're all going to do this if they haven't. One thing that not all states might do is to change the makeup of the state short-time compensation program. There's a great deal of extra money provided by the federal government, that is to raise from 50% to 100% the federal share of such programs through December 31. And to just shortcut this message, it is possible that you can make your full wages on unemployment even if you are retained by your employer for a significant number of hours per week. That's what a short-time compensation program is. It lets your employer continue to keep you on the payroll while you also get unemployment compensation benefits. This is, the Emergency Fmla Expansion Act is one of two divisions of acts that are being frequently confused. I'm going to talk about them separately because they are separate. They may, depending on regulations we haven't seen yet, interact with each other in some ways. But the Paid Sick Leave Act and the Emergency FMLA Expansion Act are two divisions of this second Coronavirus Response Act. Both of them are effective from April 1, 2020 through the end of 2020. Both of them apply certainly to employers of 50 to 500 employees. If you have more than 500 or more employees, you're not covered by this law. If you have less than 50 employees, you're probably not going to be covered, but that's going to depend on the content of DOL regulations that we haven't seen yet. The FMLA Expansion Act, it adds on to the existing Family Medical Leave Act. It covers employees who are on the payroll for at least 30 days, who are not laid off, and who are not a healthcare provider or first responder. To get the benefits, you have to be unable to work or telework due to a need for leave to care for the son or daughter under 18 if the school or place of care has been closed, or if the child care provider is unavailable due to a public health emergency. I'm going to throw in a complication here simply because I've been asked the question today. Does this erase the rest of the Family Medical Leave Act and substitute something different? No, it does not. Everything the Family Medical Leave Act did before, it does now. Except that there are new reasons for leave, there's a new pay requirement, and the definition of employers has been changed. It used to be 50 or more, now it's up to 500. What is the definition of a healthcare provider? Well, the law references the current FMLA rule. Here is the list of people who are in the current FMLA rule healthcare provider: an MD or a doctor of osteopathy, podiatrist, dentist, clinical psychologist, optometrist, chiropractor, nurse practitioner, nurse midwife, clinical social worker, physician assistant, and any other person from whom the employer's group health plan would accept a medical certification. Now, you and I can both understand why this makes perfect sense in the FMLA medical certificate world. I'm not sure that when the regs come out, they're going to hew to this list exactly. I'm hoping they will be expanded somewhat because we all know that today, the absence of someone who is not on this list can make an entire medical team in some situations useless to the patient. And the point of having an exemption from the benefits for healthcare providers is the employer can require these people, at least incentivize them to continue working, not allow them to take off with the new paid leave. I'm hoping that this list will be broadened, but I can't promise anyone it will be, or the extent to which it would be. The first 10 days of benefits are unpaid under the FMLA Expansion Act, and you'll see why when we talk about the Sick Leave Act, because this is where the Sick Leave Act fits. After that, you get 2/3 of your regular rate of pay, and that's an FLSA term, regular rate of pay, thereafter, up to the lesser of the FMLA maximum for $200 a day and $10,000 total. For employees on varying schedules, you judge the amount of time they would have worked by their average for the last 6 months prior to taking the leave. The statute doesn't expressly integrate the Fmla Expansion Act with the Paid Sick Leave Act. It's up to the DOL Secretary to do that. You get reimbursed for what you spend on paid sick leave under this act by taking FICA tax credits at the rate of what you pay. Is what you're required to pay. If you choose to pay more than $200 a day up to $10,000 total, you may, but your tax credit will be capped at $200 a day and $10,000 total. Now, here's a second act within this big omnibus act that I just talked about, the Emergency Paid Sick Leave Act. Your coverage here does not depend on whether you're a covered employer under the FMLA, but the definitions are pretty much the same. The act also is effective from April 1, 2020 through December 31, 2020, but DOL has said will not enforce this new act for the first 30 days of effectiveness, that is during April. It applies to all government employers, plus private employers of fewer than 500 people. The definition of employee is FLSA definition, not the IRS definition. This is the broadest definition that exists in federal law. It'll cover a lot of people who you might think of as, quote, contract employees or temporary employees or other people who some employers don't properly treat as employees, but who are under the Fair Labor Standards Act employees. The full-time employee gets 80 hours of paid sick leave. Part-timer gets that percentage based on the average of a 2-week period. We don't know what 2-week period. That's going to have to be defined in the upcoming DOL case. If there is no set agreement and there's no set schedule and somebody has just been hired and because of this act they're immediately available to take this benefit, then the new hire's reasonable expectation at the time of hire governs. In other words, the law is telling you if you want to nail this down, you best put it in writing with your new hires. Otherwise, their reasonable expectation as to their schedule at the time of hire will govern the amount of benefit they're entitled to take. The cap on this pay is $511 a day or $5,110 for reasons 1 to 3 that I'll discuss shortly, or $200 daily and $2,000 in total for reasons 4 to 6, and that accrues at 2/3 of the regular rate rather than the full regular rate. This is very complicated, I know. Sorry. You're just going to have to go to DOL regulations when they're available and read them over. These are the new reasons. 6 new reasons for paid sick leave. The heading says FMLA, but this is paid sick leave. First, federal, state, or local isolation or quarantine order. Now, this isn't a suggestion of some local leader. This is an order. Also notice that you don't have to be sick to use the leave under reason number 1. And for this, you get the maximum benefit. Same thing with number 2. Healthcare provider advice to self-quarantine. This doesn't necessarily mean you have to be sick. You might be or you might not be. For example, you could simply be in a high-risk health category and be ordered to self-quarantine. And again, for this, reason number 2, you get the maximum benefit. Third, COVID-19 symptoms plus you're seeking diagnosis. Again, you might not have this particular virus. You might have the flu. If you're absent from work, you're seeking a test, and you qualify for reason number 3. For those, you get the maximum benefit. Reasons 4, 5, and 6, you get the reduced benefit. Or you're caring for another covered by reason 1 or 2. 5, you're caring for the employee's own son or daughter due to the closure of school or daycare or child care provider. Notice that this is the same as the expanded FLA. 6, any similar condition identified in the upcoming regs. When are those regs going to be out? Well, they have to be out according to statute by April 2nd. I'm hearing from friends in Washington that they are aiming to get them out by this Friday afternoon. Just this week, we have seen DOL post on its website, dol.gov, some helpful guidance about how the 2 acts, the Fmla Expansion Act and the Sick Leave Act, interact with each other. And this is where I got my comment telling you that those first 10 days that are carved out of the Fmla Expansion Act are where the Paid Sick Leave Act fits. understanding based on this comment is that DOL is going to come out with a regulation saying if you qualify, you must take your paid sick leave act time first, and you must take it in one chunk. You can't do it from 3 o'clock to 6 o'clock every afternoon for 10 weeks. Not like intermittent FMLA leave. You take it in one chunk, and then you take your available Fmla Expansion Act leave. What does an employer do to recoup its costs if you have to pay all this new sick leave? Well, this is a really unprecedented program the IRS is rolling out. The early guidance is up on the IRS website. It came out March the 20th. You are going to get to withhold from what you would normally remit to the IRS the amount of required leave pay you have paid, and you withhold it from federal income, Social Security, and Medicare payroll taxes that you would have sent in. So the example here is you owe $8,000 in payroll taxes, but you paid $5,000 in sick leave. You retain the $5,000 you paid and remit to the IRS only $3,000. If you owe $8,000 and you pay $10,000 in sick leave, you retain the $8,000 you owe, getting you down to $0 you send the IRS, and then you file a claim on Form 941 for the extra $2,000. I have gone very fast, and I'll take questions at the end, but to get through this, we're going to have to go very fast. Thank you for your patience.
Thank you, Pepper. Next up, we have B. Tolsdorf. B is in our healthcare practice group. Her practice focuses on healthcare regulation and compliance work. She provides advice to clients on wide-ranging issues and clients from individual practices to large hospital systems on a wide variety of healthcare issues. Recently, B has focused in on the telehealth industry and its impacts as a result of the COVID-19 situation. B?
Good afternoon, everybody. I hope you can hear me okay. Please let me know if you can't. I'm going to talk a little bit about telehealth today. And while certainly more common in recent years, in the past few weeks, we've been hearing a lot about telehealth. And while it has been more common, there's still a lot of uncertainties just about telehealth in general. So I thought I might just give a really quick overview of what telehealth is. Now, of course, it's going to vary from state to state, the actual definition and the ins and outs of telehealth vary from state to state, and also based on who your payer source is. But generally speaking, telehealth means that healthcare services are being provided by a physician or a practitioner through the use of an authorized telecommunication system to an individual that's in another location. They're not in the same location as the physician or the practitioner. And the reason you've been hearing more about telehealth in the past few weeks is because of the healthcare crisis related to COVID-19. Clearly, the goal is to prevent or help slow community spread of COVID-19, and telehealth can play a big part in that, because it'll allow people, especially those that are more vulnerable, to receive needed healthcare services without having to go and leave their home and go to a hospital or a doctor's office. It'll also create more availability at those healthcare locations to allow people to provide services related to COVID-19. So to help facilitate that, on March 6, 2020, the Coronavirus Preparedness and Response Supplemental Appropriations Act was enacted. These hyperlinks that you'll see on these slides should be able to take you, hopefully, or provide you the web address for a lot of these documents. But this was enacted, and one of the big things that it did was it authorized the Secretary for Health and Human Services, you hear them also referred to as HHS, to temporarily waive certain telehealth requirements related to Medicare beneficiaries during the COVID crisis. Now, the act authorized it. CMS announced everything related to the expansion of telehealth services on March 17, 2020. And again, you can see there where CMS has been really good about updating their websites with facts and questions and things that will help providers understand what the waivers are doing, because as Peppers mentioned and as Walter mentioned, it's a fluid situation. Things change day to day. So some of the key elements of the federal emergency waivers relate to the removal of geographic locations with regard to the beneficiary. Traditionally in original Medicare, the beneficiary could only receive telehealth services if they were located in certain rural areas and if they went to certain facilities to receive those services. So as part of this waiver, beneficiaries are now going to be able to utilize telehealth services in their home, and they do not have to be located in a rural area. Essentially, it's opening it up to all Medicare beneficiaries, regardless of location. Now, this is going to be effective for services beginning on March 6th, the day the actual act was passed, and that'll remain in effect until the end of the declared emergency. One of the things that remains to be required, though, is an audio-video telecommunication system that requires real-time and allows for real-time communication. Now, what has changed is that now you may use telephones that had these capabilities. Previously, there only certain telecommunication systems could be used, so this is allowing a wider array of devices and systems that can be used to help provide telehealth services. And I mentioned earlier about the frequently asked questions regarding to telehealth. CMS, you can see that hyperlink there, has a really, really great frequently asked questions that relate to just common sense questions that providers have about this expansion of telehealth services. One of the things that the federal waiver did not change is who's authorized to provide telehealth services. Those are typically physicians and certain non-physician practitioners, such as nurse practitioners, physician's assistants, certified nurse midwives, and then there are other practitioners such as certified nurse anesthetists, licensed clinical social workers, clinical psychologists, and registered dietitians and nutrition professionals. But they have to be, their scope is within their they have to provide these services within their scope of practice and consistent with the Medicare benefit rules. So that was not changed by the waiver. Another large change that the federal government enacted deals with Hipaa. Telehealth still has to be provided through a system that's Hipaa compliant. These systems can be expensive and they can take time to set up. So in response to the health crisis and the urging to use telehealth, the Office of Civil Rights made an announcement that it will use its discretion in imposing potential penalties on providers that don't comply with all aspects of the Hipaa rules when providing telehealth services. And that hyperlink there will take you directly to the OCR guidance on this. But lots of applications such as FaceTime typically would not be considered Hipaa compliant. However, if there's a good faith effort to have the telehealth services provided in a confidential and you're using your best efforts to provide it in a confidential way, then OCR is going to use its discretion as to whether or not issue penalties. Now, I would note out, it does not say that they won't issue penalties. It just says that they are going to use their discretion. So obviously, try to use best practices there. And if you are able to provide these services and already do provide these services through a telecommunication system that is HIPAA compliant, it would be best practice to continue to use that. I will note that the OCR discretionary notice doesn't seem to impact any other aspects of HIPAA, just simply about the telecommunication system platform that that people are using to conduct telehealth. One other thing about HIPAA that I would say is to be sure and check your state standards. We're going to get into this too in just a second, but the relationship between the federal requirements and the state requirements, they are trying to make them as connected as possible. But obviously, you'll have your federal requirements, and then you'll also have your state requirements related to the protection of health records. So be sure to check both federal and state guidelines as you go through this process. And that actually does bring us to state telehealth requirements. I mentioned earlier that how each state regulates and reimburses for telehealth services depends on their own laws, rules, and regulations. So while Medicare has issued their guidance and their waivers, those are for Medicare beneficiaries. States will have their own responsibility of issuing guidance for private payers, Medicaid. Of course, largely state Medicaid agencies are following federal guidelines, but still very important to check and see what your state is saying about telehealth. I listed here some great places to start that process. Of course, it's great to reach out to legal counsel for assistance in the process of determining whether or not how and when you can provide telehealth as it relates to COVID or other times where there is no declared state of emergency. But the State Medical Licensure Board, the State Medicaid Office, State Department of Health, Mental Health, the State Department of Insurance, or any other regulator of private insurance that you may have. And of course, you need to be in close contact with your actual private insurance plans, because they will certainly have their requirements related to appropriate measures for telehealth. Just some examples of some waivers or some relaxations that have been had with regard to telehealth. For example, in California, they have issued requirements that insurance plans, including the Medi-Cal managed care plans, that they all reimburse for telehealth services in the same manner and in the same way as they would if the service was provided in person. There are other changes and waivers that California has issued. This is just an example to give you an idea of what your states may be doing and what you need to be looking for. In Florida, an emergency order has been issued related to COVID-19. Part of that emergency order was to authorize healthcare professionals that are not currently licensed in Florida to provide telehealth services to a person located in Florida. Now, as with anything, there are always limitations, and there's usually a process to follow. So be sure and check out if you're interested in having some sort of telehealth service provided in a state in which you are not licensed, to check their licensure divisions and bureaus to see what process they have for that. I would say both with California and with Florida and with any state, even since doing this presentation, they have both issued supplemental updates with regards to billing, coding, additional guidance. So again, just be sure to stay up to date with the federal guidance, state guidance, and your state regulatory entities with regard to telehealth.
Thank you, B. Next up is Stephen Cohen. Stephen focuses on complex commercial and appellate litigation, including insurance coverage, rights, opinions, and litigation. Stephen is a member of the COVID-19 focus group here at Balch and Bingham and has been focusing his recent efforts on identifying the issues, problems, and concerns relating to business interruption claims. Stephen, did we get your tech situation worked out? Can you speak?
I know he was still having issues a little bit ago. It looks like he is in the room. Stephen, if you can talk.
Hello?
Yay! Yep, you're on.
Well, glad that we were able to get that technical issue worked out. Can everybody hear me okay?
Yes, continue on.
All right. Has had a lot of activity over the last couple of weeks, especially related to COVID-19. Business interruption obviously is the type of insurance that covers the loss in profits when you have an interruption in your business. That's kind of standard business interruption coverage. There's also contingent business interruption coverage, which is maybe your supply contingent or supply chain disruption insurance. And then if you have an event, you might have special event cancellation coverage. I think most applicable to you guys, although I don't want to assume anything, is probably standard business interruption. Some other things you should be thinking about: workers' compensation. There's been a lot of chatter about if people go to work and they get sick from being at work, are they going to have workers' comp? Is at one of your facilities and they get sick, do they have a claim against you? Your general liability policy in that situation, I think the consensus right now is probably is going to pick up that claim, at least the defense of it. But you would obviously want to talk to an attorney about that if a claim were to arise. All right, so the rules of insurance is always, the first rule is read your policy. There are some state rules that might override some of those provisions. That contract is going to control. It's going to be specific to you and your insurance carrier. The second rule is each state is different in the way they treat insurance policies. So just because you have a policy, you heard about somebody who didn't have coverage in Florida, but you're in Alabama, you might have coverage. The same person didn't get coverage doesn't mean you don't have coverage. When it comes to business interruption insurance, there are 3 typical triggers for coverage. The first one is direct physical loss to property. And that is going to be a tough situation when it comes to COVID-19 because it's a virus. It doesn't really do any damage to your building. Noxious odors is not going to be enough to trigger that direct physical loss. There are some states, however, that have looked at situations, say maybe there was a gas that infiltrated and contaminated a building. In those states, they've said, that's enough to cause direct physical loss because it made a physical alteration to the building itself. There's just no good answer out there right now. And the reason is we've never seen anything like this before. The losses are going to be pretty bad for a lot of businesses. And there's just a lot of uncertainty as to what is a direct physical loss. So, if you have any questions, I always say, I've been telling clients, go ahead and make a claim. There's no penalty for making a claim. If the states law, if, 2 years down the road, a case comes out of the Supreme Court and says, hey, direct physical loss means viral contamination, but you never made a claim, you won't be able to make a claim then. It'll be too late. Two other types of coverage that you might see would be an order of a civil authority. Typically, a civil authority order means that there has been a fire in your property, and it is the case, and it really is dependent on the language of the particular policy. Most of the policies I've looked at so far, civil authority coverage is not really available, but I have seen a couple of examples out there from my colleagues in the industry that have indicated you probably would have civil authority coverage. Another problem with civil authority coverage is that it typically is not going to, because the governor issues an order and says we're going to shut everything down. Typically, that's not the kind of order that triggers civil authority coverage. Ingress and egress is just means that you can't get into your property. It means there's some barrier getting you in and out. And a lot of the policies I've looked at so far don't have this coverage, but I just wanted to mention it. All right, typical barriers to coverage. We talked about direct physical. If you can just go in and wipe the virus off with Clorox wipes, is that going to be enough to get you coverage? Because typically there's a 24-hour or 72-hour waiting period to a business interruption insurance policy. You also have policies that have what's called named perils, and you have some policies that have all risk, which means they covered any risk not specifically excluded. A lot of times, a big question right now is, do you have to shut down completely? Sometimes businesses are able to keep part of their business open, but they can't work in another part of it. And so that, in some policies, you have to have a complete shutdown, and others I'm getting some feedback. All right, so the virus exclusion is going to be pretty potent. This is something that the insurers wrote into their policies so they didn't have to cover pandemics. And we're going to look at that in 1 second. And then the pollution exclusion, a lot of times pollution is a virus is considered a pollutant. And so a lot of policies exclude coverage for that. Move pollution. And it's just if you read this part B here where it says we will not pay for loss or damage caused by or resulting from any virus, I mean, that's the exclusion insurers wrote into their policies so they don't have to cover these kind of pandemic losses. And if you have this exclusion, you probably don't have coverage, but that's always policy specific, and you should always seek, going to have coverage. If you think you might have a claim, here are some things you should do. You should notify your carrier. Again, if you don't notify the carrier, you can lose your claim and never have a chance to bring it. If you make a claim, the worst that can happen is the insurer will deny it. To make sure that you have a complete shutdown, be sure to document everything. And I've got a link here to a template that example specific to your carrier. So reach out to your broker and ask them for help. And then mitigate your losses to the extent possible. Here's just a list of kind of things you can document. And then I just want to briefly touch on, there is some legislative chatter about legislatures forcing insurers to vote did not happen. There's some serious constitutional questions as to whether the legislature can constitutionally require people to cover losses that aren't in their contracts. And we're seeing Congress take interest in this as well. There's some representatives that sent a letter to some insurance associations, and I just wanted to read you here the bottom part, which is the associations wrote back the next day in diseases such as COVID-19. So the insurers are pretty adamant, we're not going to cover this because, I mean, this is a potential existential threat to them. I mean, some of them would be forced into insolvency if they had to cover these losses. So just in conclusion, if you've got insurance questions, read your policy, talk to your broker, check the law in your state, and don't give up just because deny claims all the time and eventually end up having to pay them out. So don't give up. And I will turn it over now, Jeremy.
Thank you, Stephen. And along those lines, we are doing reviews of insurance policies for clients who have questions about whether or not they have business interruption claims. So next, we have Jeremy Rutherford. Jeremy practices in the firm's bankruptcy and creditors' rights practice group, representing primarily lenders and other creditors. Jeremy's practice focuses on rights and remedies after default and resolution of complex business disputes. Jeremy's going to talk about businesses in crisis and some practical steps you can take. Jeremy?
All right. Thank you, Walter. Thank you, everyone, for
Jeremy, I've unmuted you now.
staying with us. The biggest thing to keep in mind as we go through this, what is most definitely a crisis, is do not panic. You guys provide a vital service to the communities in which you live, a service that is needed desperately during this time. And so when you're thinking about the dollars and cents, and I know this is easier said than done, but do not panic. You have employees looking up to you, seeking guidance and leadership from you. You have investors doing the same in many respects, and then you also have the people that you're providing that service to. So with that, at that point made, a couple of practical things to keep in mind, if I can get back to my, there we go, the slide. Assess your cash situation, something that any good business person is going to be doing on a regular basis, but doing it now is most important. Knowing where your sources of funds are coming from and what's going on with them, with the insurance companies and the like. Looking at where you can cut expenses and doing that. I had a conversation yesterday with a large regional service provider in the landscape area. And they were telling me that they're getting calls left and right, not surprisingly, from people canceling enhancement projects at this time. Just if it's not a necessary expense, people are holding on to that cash. Also start looking at a priority list of payment. If cash did get higher than it already is, and you were faced with a situation of not being able to pay all of your bills at one time, what are the mission critical bills and which ones could you maybe not pay for a month or two? Another thing to consider is, do you have assets that you're not using that you could sell fairly quickly, but not at a fire sale price as a way to generate cash? You should also consider, to the extent you have the luxury of availability on lines of credit, possibly going ahead and taking advantage of that. A number of companies, a number of large companies have been doing that and continue to do that, again, just because of the uncertainty that we're in at this point of time. Communicate with your creditors. This is going to be critically important. And by this point in time, I would suspect that many of you have already had those conversations, primarily with your principal lenders. A lot of banks, both large and small, are offering deferment programs, anywhere from 30-day payment waivers on up to 90 days and maybe even beyond. Some banks are sending these type notices and making these programs available to all of their customers, but others are not. Others are only providing that if you ask for it. So if you don't ask for it, you may not be able to take advantage of that. Know that those payment deferment options exist, but understand exactly what you're doing. And in this point in time, this may not be an important thing, but if you're not making a monthly payment, then that may mean over the life of the loan, you're going to pay more in terms of interest. Again, when we're talking about just being able to have enough cash to get by, that may not matter, but understand exactly what you're doing. Keep in mind that a refinance is a possibility. Another thing to keep in mind, and Conrad may speak to this a little bit, is that there are SBA loans out there as part of the stimulus packages. And that may be a quick source for funds during this time. And thinking about it a little bit further down the road and the possibility that you may have to look at a bankruptcy filing, there are some things that you can start doing now to help better position yourself should that situation ever arise. One, to the extent that your company includes several companies under the same umbrella, understand that those separate LLCs serve a purpose. And it's more than just that's what the lawyer said to do. And so be careful not to fall into the temptation of, if company A is low on cash, simply pay company A's bills out of the bank account of company B. Those are separate and distinct companies. And if one or both of those companies end up filing bankruptcy, it's going to be critically important that those corporate formalities are respected in the weeks and the months prior to the bankruptcy filing. That's not to say that you can't use the money from company B's accounts to help company A, but you've got to document those intercompany transfers properly. And that's where you want to consult with your attorney and your accountant on how to do that. A lot of folks probably aren't even thinking about the word bonus at this time, or certainly not distributions, but to the extent that you are, think about how that's going to look down the road if you do go into a bankruptcy filing. You want to be careful that you're not suddenly making dividends and distributions to equity holders of the company while creditors are going unpaid. Just a very quick crash course in some bankruptcy concepts in closing. And again, these are very high level and things that you would want to talk to your attorney about. But there are, for businesses, two different types of bankruptcy. A Chapter 7 bankruptcy is a liquidation. That's where you go into bankruptcy court, federal bankruptcy court. You give all of your assets to a bankruptcy trustee. They liquidate those assets at a fire sale and give the proceeds to creditors. A Chapter 11 is typically used to reorganize, and depending on your individual situation, that may be exactly what you need to do, is to reorganize rather than simply to liquidate. When you file bankruptcy, probably the biggest advantage, initial advantage, is the fact that an automatic stay comes in place that stops creditor actions, lawsuits, foreclosures, garnishments, things like that. Two very important points to keep in mind, both from people that may be thinking about filing bankruptcy and those who may have other folks, maybe people that owe them money that may be filing bankruptcy, is the idea of a preference payment. Any payment made within 90 days of a company going into bankruptcy could be clawed back as a preference. There are a lot of nuances to this, but if you've got someone that owes you money and suddenly they are paying you current out of nowhere, understand that, first of all, you absolutely take the money. No doubt you take that money, but understand that if they file bankruptcy, that may be clawed back as a preference. Just like if your company is going into bankruptcy and you decide you want to take care of certain creditors over others, and so you pay them current over others, you may see that being clawed back as a preference. There's also the concept of a fraudulent transfer, really both in and out of bankruptcy, but you see it more in bankruptcy. And that is simply a transfer, as the name suggests, that is done fraudulently, done with the intent to hinder, delay, or defraud creditors. But it also may be not with that intent, but if it's a transfer made when your company is insolvent and your company is not getting what's called reasonably equivalent value, that transfer could be clawed back. I realize that is a lot of information in a 10-minute segment about bankruptcy and related issues, but if you have any questions, we can certainly take those at the end. Walter?
Thank you, Jeremy. And last but certainly not least, we have Conrad Anderson. Conrad is a tech-minded trial attorney who litigates all manner of business disputes. Currently, Conrad is working with our firm's governmental relations practice group to monitor the legislative and executive action that has been happening as a result of COVID-19. Conrad?
Thanks, Walter. As I'm sure you've seen in the news, there's been lots of movement this week on this, what's been called Phase 3 stimulus package. As it stands right now, the Senate passed the Coronavirus Aid, Relief, and Economic Security, or CARES Act, last night. It has not gone into law yet. It's expected to get approval in the House tomorrow. But as we all know, those things can change. So here's where we are and where we think we will be after tomorrow. It's been called the largest rescue package in American history. It's valued at over or close to $2 trillion. This is a very high level overview. If you want more detail, you could read the 853-page act. But there's $250 billion going directly to the individuals and to families, $250 billion for additional unemployment on top of what you get from the state. There's additional SBA loan relief. The Treasury will be overseeing a $500 billion loan program and loan guarantee program. That's where the money is coming from for the airlines and whatnot. There'll be $100 billion going directly to hospitals, specifically for COVID-19 response efforts, and $240 billion for healthcare relief related to this specific crisis for treating COVID-19, and then $150 billion for state and local governments to specifically combat the virus. As far as the cash payments to individuals, where we ended up is that they want to send as rapidly as possible payments directly to taxpayers or to all residents, and it'll be $1,200 for individuals and $2,400 for married couples, plus an additional $500 per child. Hasn't been clarified yet exactly how that money is going to get to you, whether it'll be directly deposited or whether they're going to send a check. But I know they want to get it out there quickly, and then those payments will start phasing out for individuals if you earn over $75,000 adjusted gross income, and for married couples, $150,000. There is the $350 billion for the Paycheck Protection Loan Program. The idea here is to get money quickly to small businesses so that they will keep their employees and so that they will not shut down. They've made it very easy to apply for this relief. They waive most of the paperwork requirements. You're eligible to take out an amount equal to 2.5 times your average monthly payroll, and up to $10 million. And that money, if it is used to cover payroll and to pay interest on debt and to pay for rent and utilities, then that amount that you borrow will be forgiven. Now, the way it's going to work is at the time you apply, you basically provide a good faith statement that you're in need of this loan and provide certain assurances, and then on the back end, you apply for forgiveness. And in order to get that forgiven, you have to show that you had a need for it, that you were affected by the virus, and that you used these funds as intended. And I'll just go ahead and tell you, it's going to be very important to document all those things to prove exactly what those funds were used for in order to get it forgiven. And the amount that's going to be forgiven will be basically the amount that you can show is used for those specific expenses for an 8-week period following origination of the loan. There's also this $500 billion loan program overseen by the Treasury that I was telling you about for corporations. There's a lot of restrictions that were placed in that at the end to try to prevent money going to executives and to others. There's companies that take this money are not allowed to declare any dividends or to repurchase any equities during the life of the loan plus 1 year thereafter. There's limitations on executive bonuses. There is they're creating the Office of Inspector General for Pandemic Recovery that will oversee those loans, and there will be public reports filed about those loans. There will also be a Congressional Oversight Committee that's a 5-member panel that will oversee this, basically so as not to end up with the situation that we had back in 2007, 2008, where it felt like this was a Wall Street bailout. So they're going to try to have a lot more restrictions on that this time. Also, one of the restrictions I'm sure you've seen is that this relief from this program is not available to businesses that are controlled by either the president, the vice president, members of Congress, and heads of executive departments. Briefly, some of the things that are allocated, the funds that are allocated for healthcare specifically, $150 billion to healthcare providers, community health centers, hospitals for funding, research, treatment, to replenish the strategic national stockpile with ventilators and PPEs to try to hopefully prevent this kind of situation in the future where we're low on supplies. $100 billion going directly to hospitals and nonprofits and suppliers. $3.5 billion for biomedical advanced research. $4.3 billion for response and preventative measures, $1 billion to supply chains, $250 million to expand the emergency preparedness procedures. And then on the mental health funds, this is coming out of the total health care package. There'll be $425 million allocated specifically to mental health services. Part of that is an extension and expansion of the Community Mental Health Services Demonstration Program, which there are already 8 states that applied for and received the authority to operate that 2-year program. This is going to open it back up to add an additional 2 states as a part of that. Then the $250 million of the 425 is specifically for the Certified Community Behavioral Health Clinic Expansion Grant Program. There was already $197 million available for those grants for 2020. Those grants could be up to $2 million per year, and so they're adding $250 million to that program. Additionally, $50 million of the 425 will have to be allocated specifically to suicide prevention, and then $100 million for these emergency response grants that are specifically for the COVID-19 crisis. And then lastly, unemployment, $250 billion provided by the federal government to help supplement what folks who receive unemployment, what they're getting from the state. The federal government is chipping in an additional $600 a week on top of whatever the recipient gets from the state. That'll continue for an additional 4 months. They're adding 13 weeks of extended benefits. They want to get this money to people quickly, so they're waiving the waiting weeks requirement. And this has also been expanded to specifically be available to independent contractors, gig economy workers, self-employed, and others who wouldn't typically be available for state unemployment benefits. So that's a very brief summary of a very large legislative package.
Thank you, Conrad. And I just want to give everyone the website again. Of course, it will be in the materials that will be available and sent to each person who's registered for the event. On the last subject that Conrad raised, we are watching in particular for the behavioral health industry what of that mental health funding might be available to those already in the industry. One of the unique things about this package, other than its sheer size, is also its recognition that this event not only has widespread health effects, but it will have mental health effects. And there was money set aside specifically for your industry. And one of the things we will be watching is how to access that, who qualifies for that and whatnot. Stay tuned. I'm putting on the screen, and you will have in the materials that are emailed to you our contact information. We are available to answer any questions you might have. So please feel free to contact us. I do know that there have been questions raised in the chat room already, and I want to kind of take up those now. If you have further questions, you feel free to enter them in the chat room, and we'll respond to them as we can, time permitting. The first question is, and this would be directed to you, Pepper. The question is, as an employer, am I required to provide 80 hours of sick leave to all full-time employees? And they say they have under 50 employees.
I'm going to give you an answer that's based on my guess about what DOL regulations would say on that. I think DOL regulations are going to say that you must substantiate that complying would harm your business substantially, but I don't think they're going to require that you make any sort of conclusive showing about that. Why? Because we're all guessing. There wouldn't be an exemption in the Act for employers of fewer than 50 unless there were an expectation that there would be a serious injury if you had to comply with these rules. So I think DOL is going to make it easy to show that if you are under 50 employees, the consequences of complying with sick leave pay requirements would jeopardize your business, and therefore you would be exempt. But you're going to have to look at the DOL regulations when they're published on dol.gov, probably tomorrow evening, but certainly by April 2nd, to determine that for sure.
Thank you, Pepper. And the questioner, of course, can feel free to contact us if you need further information or follow up on that. The next question that I received is for you, B, and it's about telehealth. And the question is, what about commercial insurance? What about substance abuse treatment centers for groups or one-on-one assessments and doctor visits? Can you provide any guidance or suggestions or general input about telehealth relating to those issues?
Sure. The California example that was given was based on some guidance that had been put out by the regulators, and it appears to cover all insurance companies. I would say that, and this would be true with any payer source, I would contact the payer source to determine how they are handling telehealth in light of COVID. You've seen lots of large insurers issue policies and statements on how they are going to handle telehealth services, and states are taking their own approaches, but I think I would still be sure to check with the actual payer source to see how the beneficiary, what requirements have to be met for the coverage to be met for the beneficiary. You see typically, and this kind of leads into my next answer, typically you do see substance abuse and behavioral health services covered under telehealth. But again, I think it would be wise to contact those entities, those insurers, and find out specifically what's being covered during COVID and what's covered outside of this declared emergency.
Thank you, B. And as with all things, there's good news and bad news. The good news is that, at least with respect to telehealth, COVID-19 has broken the logjam that many have been pushing for a while to increase the exposure to this valuable avenue of care, which is particularly relevant to the behavioral health industry. So more will be seen, but B is right. Check with your payor sources, check your plan documents, and use this as an opportunity to increase that if you're able. The next question, I think, is also, go ahead, B.
No, I was just going to follow up exactly with what you were saying. That's so true. The purposes of these waivers and modifications are to make telehealth more accessible, not to restrict it. So if it is something you're interested in pursuing, whether it's the first time you've done telehealth or the millionth time you've done telehealth, it's something that is certainly out there. It's available, and the rules are not being thrown in the trash by any means, but we have seen that they have become very relaxed and certainly waived in some instances. But you need to contact those the plan administrators, the regulators, and verify with them.
Okay, the next question is a particular one that we may not know the answer to. It's from Donna, and she asks, is V, as in capital V, capital SEE, VC, approved for substance use counseling? And I assume VC is a mechanism of telecommunications, but B, do you know the answer to that?
I do not know off the top of my head if that is a authorized, typically HIPAA compliant platform. I will say that OCR has published, and that link provided in my slides will take you to the website where OCR has said what are typically HIPAA compliant platforms, and what platforms, while not typically compliant, may be used during this time. I can't say that off the top of my head, though. I am familiar with VC, but I'm sure that checking out that website with OCR can provide you some guidance on that. One thing I would like to say is that, and I touched on this briefly, is I would strongly, strongly, strongly caution everybody to not use any platform that, one, you already know is HIPAA compliant, or a platform that has not been acknowledged by either OCR or your state by, states are having to file 1135 waivers, which include, and some of those waivers are including, similar loosening of privacy requirements, similar to HIPAA, just on the state level. So I would strongly encourage you to either use a platform that, one, is HIPAA compliant. Obviously, that's not going to be possible for everybody right now, especially new providers, or to use a platform that OCR or your state has acknowledged as an appropriate platform during these times.
Thank you, B. That's all the questions that I see in the chat room. I wanted to reiterate again our thanks to our sponsors, the Behavioral Health Association of Providers, BHAP, and Southworth and Associates. We appreciate you helping us get the word out. I would also like to draw your attention once again to our COVID-19 focus group page, where we have day-by-day, up-to-the-date information on COVID-19 news that may affect your business. If we can be of further assistance to anyone, please let us know. We hope everyone remains safe, and we thank you for your time this afternoon.
Okay, well, while we're waiting to see if anyone else has any questions, I also mentioned in the chat room, I looked at the list. It does look like VC is on the list of approved vendors, but I would just double check before you start using it. I want to thank again the staff of Balch and Bingham for presenting today. Thanks as well to Southward Associates for co-sponsoring the webinar. Finally, thanks to everyone in our audience for participating and bearing with us during our technical difficulties. A reminder that a link to the webinar and the PDF of the slides will be sent out via email in the next few days from an email that ends with the bhap.us handle. Be sure to keep your eyes out for it. We've also been compiling resources on our own, as well as news stories on COVID-19 on the BHAP website and social media. Feel free to reach out to us if you can't find them. We hope that you join us for future BHAP webinars. You can sign up for our various newsletters, which includes emails specific to upcoming events, at our website, www.bhap.us. And if there are no further questions, this concludes today's webinar. Thank you very much.